Morning. Next case is Askew et al. Versus City of Kinston, and we will hear from the appellant.
May it please the court, I'm Attorney Ralph Bryant with the Carteret County Bar. I'm here on behalf of my clients, Joseph Askew and Curtis Washington. This is a lawsuit that we filed against the City of Kinston, North Carolina. In this lawsuit, we have alleged that the City of Kinston has systematically engaged in the destruction of properties and homes within the African American community, that the City of Kinston has specifically targeted the African American homes owned by African Americans and targeted the African American communities, predominantly Black African American communities. We filed the lawsuit. There was a motion to dismiss that was denied in the trial court. Then it went on to summary judgment. At the summary judgment stage, the trial court granted summary judgment without stating any reasons for why he was granting summary judgment. We then, at the Court of Appeals, upheld the grant of summary judgment, but it upheld the grant of summary judgment based on the decision that we have failed to exhaust administrative remedies, specifically NCGS 160A, that provides some processes for persons whose homes have been subject to demolition, provides some processes through the municipal board, and then a review at the judicial review. And the Court of Appeals held that we were required to engage in that process instead of filing a direct constitutional claim like we have filed. Your Honors granted review on our appeal of a substantial constitutional question. We've raised two constitutional issues in this case. The first constitutional issue is the constitutional issue of equal protection under Article 1, Section 19 of our state constitution, which states that the state shall not deny the equal protection of the laws, but it goes on to say that our Constitution goes on to say that the state should not discriminate against persons because of their race. And in this particular case, we're alleging that the City of Kinston has done just that. I'd like to read for you just a few of the paragraphs from our complaint with the allegations that we have made against the City of Kinston. And we state the City of Kinston building inspector and the City of Kinston's inspections department have engaged in the systematic destruction of buildings owned by African Americans and/or buildings that are located within a community that is predominantly comprised of African American residents. The City of Kinston has operated this systematic destruction of African American buildings under the guise that the city is demolishing dilapidated properties. But however, the city is using the process for demolishing dilapidated properties in a racially discriminatory manner. The condemnation and demolition of the properties was motivated by the conscious decision to demolish buildings that are owned by African Americans or buildings that exist in the African American neighborhoods. The City of Kinston has failed to play, in the African American neighborhoods. So our first claim for equal protection is that the equal protection law is denied. Our contention is that when we make an equal protection claim, it's not necessary to go through NCGS 160A, to go through that process in order to be able to assert our constitutional claim. Our contention is we should be able to assert a direct constitutional claim without that process. The first reason.
So the Court of Appeals didn't seem to have to decide that question. As I read the Court of Appeals opinion, it kind of has two parts, and the first part starts out and says subject matter jurisdiction, and then describes how you have to exhaust administrative remedies to confer jurisdiction on the court system. And then it has another section that's exhaustion of administrative remedies. The claims you brought are quorum claims, am I right about that? Direct constitutional quorum claims?
Yes, sir.
So is there any obligation to exhaust an administrative remedy before bringing a quorum claim? Has our case law ever said that?
Your Honor, I have not found it, and that's one of the points that I've made, particularly with regards to the substantive due process claims. It specifically stated that it is not required to exhaust administrative remedies to assert a substantive due process claim. So, the same reasoning, I haven't found the case that says it in North Carolina, but the same reason it applies to the equal protection claims, that if you're going to make a direct constitutional claim, that you should not have to exhaust administrative remedies to make that claim.
So there is a component of quorum that says if there is an adequate alternative remedy. But that was not the basis for the Court of Appeals decision. Like, my question to you is, could we reach that question of whether there's an adequate remedy under quorum, or is that something that we need to send back? The Court of Appeals needs to never even got to that and should get to it before we do.
Thank you. Your Honor, yeah, and I tried to raise that in my brief, that I thought the Court of Appeals analysis was misconstrued to focus on the exhaustion of administrative remedies, that the real issue is whether or not there was an adequate state remedy. I would ask you to, based on the case law, to decide that even if you address that issue, there is not an adequate state remedy. I mean, the idea that what we're asking the court to do is something that the courts have always held is in the province of the court itself, which is to make the determinations of whether or not there was a constitutional violation. In this instance, the only process that they have is a process where the city council can go and determine whether or not, you can appeal to the city council. But the case law is clear that municipal officers, city councils don't have the right to determine constitutional issues. That is within the province of the court.
But they could have halted the demolition.
I'm sorry.
Down here, to your left.
Okay, I'm sorry.
That's okay.
Excuse me.
There are quite a few of us up here. So.
And I have advanced glaucoma, so I have difficulty seeing.
Yeah.
So.
Yeah. But you could have, but had you used the process, there would have been the possibility or the opportunity to avoid the demolition, wasn't there, and therefore the constitutional violation.
Well, the constitutional violation is in our contention. The constitutional violation is when the city made the decision to target these homes because of race. That's the constitutional violation, and whether or not later somebody says, well, the demolition was upheld or not, doesn't reach that issue. The issue is if you're targeting that community based on race, if you're targeting that building based on race, then that's an equal protection question that can't later be resolved.
But why couldn't you raise it in an appeal from a decision of the council to Superior Court under 168-393?
The council does not have the authority to make that determination, the equal protection determination, and so.
No. Why couldn't you have argued that the council's action or the city's actions in the case were unconstitutional in an appeal under 168-393, which specifically allows the court to reverse an action if it's unconstitutional, right?
There's a statute that says that, Your Honor. I would contend two things. First of all, is that the legislature, in saying that the court can review the council's decision, and saying that the court can review that and also review the constitutionality of the council's decision. I mean, that, even though they didn't say it, they're really talking about the procedural aspects of it. They've got to be, because the city council, they can't review the city council's decision based on equal protection and substantive due process, because the city council does not have the power to make that decision. So when they're reviewing, the only thing they could possibly be reviewing is whether or not there's some type of procedural due process involved that does require exhaustion of administrative remedies. But our equal protection claim and our substantive due process claims does not require that. And so in summary, I don't think that the legislature has the power to take from this court the right to decide equal protection and due process claims and say that they get to go, you have to appeal it through the.
But it's really, to go back to what Justice Dietz was saying, it's really not about taking power from the court, it seems to me. It's a question of whether the remedy provided is adequate. So I don't see that dichotomy that you see there.
Yes, sir. If I can address that, the cases that talk about adequate state remedy, they talk about adequate state remedy from the point of view of, okay, you're making a constitutional law claim. Is there a tort over here that will give you the relief that you're looking for? In this case, what the defendants are trying to say, well, you're making a constitutional law claim. There is a statute that lets a judge review the constitutional law claim. So it's not saying that there's a different remedy. It's saying there's a it's still the constitutional remedy we're entitled to get. They're just trying to say the only way we can get to bring this constitutional claim is by the 10-day process. I think you get 3 to 5 minutes to talk at the hearing, and then you get 10 days to appeal it. They're saying the only way we can bring this claim is if we go through that narrow process. But at the end of the day, they're saying we're still entitled to the constitutional claim. We just had to go through the process to get in. I would assert that with regards to equal protection and substantive due process, that they don't have a right to do that.
What I'm trying to get to, though, is why is the process inadequate?
Yes, sir. Okay.
That's what I'm trying to get to.
Yes, sir. One of the reasons the process is inadequate is because of the process itself. You know, this process, when you're talking about going through the city council, you're basically given 10 days to appeal the demolition decision, and then you're given whatever minutes to talk. Okay. The other thing is the process itself does not allow for the monetary and injunctive relief that we're asking for. Right? In our lawsuit, we're asking for, first of all, some kind of order that we pray issues from the court at some point, telling this city and other cities that targeting these African American communities or any community for demolition of homes using this demolition ordinance, that this cannot happen. But the other thing, we also ask for monetary damages, and those damages are not recoverable under 160A, and even under a recent case from this court, the court talks about it not being an adequate state remedy. You know, when you can't get those types of damages. Is
there a constitutional injury in claim even if the city never decides to condemn or order demolition? That is, and this goes, I think, to Justice Deet's question about bringing a direct constitutional challenge. If there's a situation where a city is targeting Black homeowners for these processes where they ask them to spend money, they ask them to stay under the oversight of the city over years, and they're not treating white homeowners the same way, and maybe it never gets to condemnation, do you still have a constitutional injury and claim there? And what happens if it never gets to the point of appealing a condemnation order?
Yes, ma'am. Yes, we would still have a constitutional claim if that's the conduct that the city is engaging in, and that's one of the big issues. Like, for instance, in this case, what if this were a citizen organization that actually filed a lawsuit against the city of Kinston and alleged that the city of Kinston was engaged in this type of conduct, right? And they wanted this conduct to stop, but they themselves had not been in the demolition process. Would they have a right to bring a lawsuit against the city of Kinston, to constitutional claim to force the city of Kinston to stop this type of conduct? I think they would, even though they were not in the demolition process itself, because it was affecting them, and they could be subject to the harm.
I want to follow up on the adequacy of the administrative procedure to assert your constitutional claims. Am I correct that the evidence that you would marshal to demonstrate that the city was making this decision about which homes to condemn based on improper racial considerations, that evidence is different from the evidence that might suggest whether or not a particular piece of property is under the city's own ordinance subject to condemnation?
Yes, ma'am. That's right.
And would you have the ability to take discovery and depositions of the individuals involved in making the decision to determine what evidence there might be of their intent?
Those individuals, and yes, and we've done it. We did it in this case.
But would you in the administrative procedure?
Oh, no, ma'am. No, Your Honor. We will not be able to do any of that. You show up, and I think, I don't want to misquote, but in my memory, you have 3 minutes on a time to speak, and then but you don't have any right to engage in. I mean, it's constitutional violation, so it's very serious. So we have to be able to engage and treat it seriously, engage in discovery, and gather witnesses and things like that, documents. And
so what about at the judicial review stage, which is sort of, I think it's supposed to be treated like akin to an appellate stage, but can you take evidence or do fact discovery on at the judicial review stage from one of these condemnation cases?
I've never done one of these condemnation cases, but I've done plenty of judicial review, and you don't take additional evidence. They basically review the evidence there, and they make decisions based on that. So I do not think, counsel can, I don't want to misstate because I really don't know, but I do not think that you have that right to do that.
And I also want to go back to the start of your argument to understand the distinctions between a conclusion that administrative exhaustion is required versus the issue of whether or not a claim can be brought because there's an adequate state remedy. And on the first question, whether or not there should be exhaustion of administrative remedies, as I understand the Court of Appeals, they determined that that's a jurisdictional issue. And in fact, they vacated the summary judgment order and remanded to dismiss the case for lack of jurisdiction. So don't we have to address the jurisdictional issue before we move on to any merits question?
I would not disagree with you that yeah, it has to be addressed. I would just, my contention is when you address it, that you find that the exhaustion of administrative remedies doctrine does not prevent us from pursuing this action.
And since that was the only basis for the Court of Appeals opinion, wouldn't we be if we agree with you that in these circumstances there is not the need to exhaust some kind of administrative procedure in order to assert the equal protection claim, since that wasn't addressed by the Court of Appeals, don't we need to remand for them to address that?
I would think so, Your Honor. I would think so.
And on the question of whether or not there should be exhaustion of administrative remedies, as I understand your answers earlier, the nature of the harm here is the fact that the government, your allegations are that the government is making a decision to proceed in the first place based on race. So in some ways, this is akin to a selective prosecution claim.
Yes, Your Honor.
And if the state of North Carolina set up an administrative process whereby the State Human Relations Commission can examine whether or not, when parties have claims of racial discrimination against a city council or other local governing body, the state, by state statute says, Human Relations Council is the first place where you bring those claims. That would be an administrative process to address issues of equal protection under the state constitution, correct?
Correct.
But this administrative process, while it seems we all agree when it gets to the question of judicial review, constitutional matters can be considered, this is not a process that the state has set up to address the question of whether or not a local government is acting in a way that is racially discriminatory.
Yeah, yes, Your Honor, I would agree. And that too, you know, the thing about it is the process that the 168 process, the statute has not given this city the right to make constitutional determinations of whether or not constitutional laws were violated or not. And so when it gets to the judicial review and the judge is trying to figure out whether they acted correctly, he's not reviewing the constitutional law issues because, you know, the case law doesn't allow it, and then the statute does not allow for the city council to decide that. There's that language in the judicial review that says that the judge can also review whether any constitutional violations occurred. Again, I would submit to you that even though it doesn't say in the statute, that's dealing with whether or not any procedural violations have occurred, because, you know, there's just no way that the judge can determine whether or not equal protection and substantive due process violations have occurred when that wasn't even addressed. It can't be addressed at that level. And
You don't disagree that the statute allows for the court to have the record supplemented with testimony of witnesses, would be depositions, affidavits, whatever other information is necessary to determine a constitutional claim. That's what the statute says, right?
right, yes, Your Honor. I will reserve the rest of my time. Thank you.
We'll hear from the appellee.
Thank you, Your Honors. May it please the Court, my name is Dan Hartzog Jr. on behalf of Appellee City of Kinston. I want to start out by pointing out that this case did go through discovery, did go to summary judgment. Contrary to what plaintiff's counsel mentioned, the court, at the trial court level, did say, we have reviewed the depositions, we've reviewed the pleadings, we've reviewed arguments of counsel, and we find that there are no material issues of fact and that defendants are entitled to judgment as a matter of law on the merits. So that, the allegations that the city was engaged in race discrimination have been ruled on by the court and found to be lacking based on the evidence. So I want to make that clear at the outset.
And so appellate courts and summary judgment, appeals from summary judgment are required to affirm if there's any grounds, because it's de novo review, that would support the, but I guess I have the same question for you. I have your friend, which is, so other bases to say that summary judgment was appropriate here, does the Court of Appeals need to address those in the first instance? Because they didn't. They seem to have addressed a completely inapplicable theory of subject matter jurisdiction and exhaustion that doesn't apply in quorum claims. So do we have to send it back, or can we, because it's de novo, get to it ourselves now?
Well, Your Honor, I would disagree that it's completely inapplicable. I do think that there is one aspect of reviewing a constitutional claim is whether there's an adequate state remedy or whether there are administrative remedies that need to be exhausted.
Well, fair enough, but the rubric you'd think about that in is the quorum context, and it seems like they were citing kind of APA-style exhaustion principles that, the quorum problem is not a subject matter jurisdiction problem. It would just mean you didn't state a quorum claim. It would be a 12b6 issue, not a 12b1 issue.
Well, I think the way the Court of Appeals was looking at it is if there is an adequate state remedy and if there is a remedy that needed to be exhausted before you can bring a quorum claim, then we don't have jurisdiction to hear the quorum claim because you didn't meet your prerequisite requirements to bring a quorum claim, which I think is correct. So I do think the Court of Appeals got it right. If this court were to say the Court of Appeals got it wrong and did the wrong analysis, then yes, I think you need to remand it back because we prevailed on the merits at the trial court level on summary judgment. There just is no evidence of race discrimination as determined by the trial court. So I think, the city would certainly have the right to have that issue heard and upheld, we believe, at the Court of Appeals level. Although I believe the Court of Appeals correctly decided that you do need to exhaust your administrative remedies. And I'll address this briefly. The issue of exhaustion of administrative remedies versus adequate state remedy, yes, they're slightly different analyses, but they are, very much tied together. Because the issue is there an alternate path for you to get into court, to bring your constitutional claim and, assert your rights? Can you enter the courthouse doors and address your claim? And administrative remedies can do that, and administrative remedies can be an adequate state remedy. And I believe that's the case here. The administrative remedy of the appeal in nature certiorari under 160A does give you the right to enter the courthouse doors, does give you the right to say my constitutional rights were violated. A lot of the cases I'll point out that were relied on here saying that you don't have to exhaust administrative remedies were prior to the amendment of 160A23 in 2019, which specifically included the right to bring constitutional challenges to your appeal. It's correct to say that the administrative board doesn't have the right to hear constitutional challenges, but the legislature specifically included that language in there saying you might not be able to address your constitutional claim at the administrative level, but on appeal in the nature of certiorari, you can address your constitutional issues. And I'll correct one thing, that I don't think it's only procedural due process, because the statute says specifically including procedural due process claims. So when you're looking at whether you can bring a substantive or equal protection claim on appeal in the nature of certiorari, it's not limited. It's very clearly not limited to procedural due process claims. It just says including procedural due process claims. That might be the most common type of claim you might see on appeal, but that is not, you're not limited in that.
But doesn't it matter what rights we're talking about in terms of whether or not you have an adequate state remedy through an administrative process, and that there's a real distinction between the right to not be subjected to governmental decision-making based on your race, that harm occurs when the government employs race to make the decision to start the condemnation proceedings in this particular case. The remedy for that harm would not necessarily ultimately be that your property can't be condemned. It might be that the government has to go back and do its process, not taking race into account, correct?
Correct.
And it's conceivable that this particular, if the government, again, I understand what the summary judgment ruling means in terms of the facts that the trial court found, that there wasn't race discrimination here, but understanding that this would apply to other cases, assuming that the government did, so there was the smoking gun email where the planning department said, we're going to we need to target these homes, how do we best do it? And they come up with race-neutral criteria, but there's the evidence that they did it based on race. It's entirely possible that they go back and say, okay, we're not going to consider race. Let's look at these other criteria. And under the other criteria, we're going to pick homes over 80 years old. Under the other criteria, this home still could be subject to the city's condemnation process, but it would not be an equal protection violation at that point. And that seems to me, isn't that very different from the question of whether or not the property meets the criteria that under the law allows the city to condemn it?
Yes, it's a different question, but the question here is, can that question also be addressed in a certiorari appeal?
And how is that possible when there's no opportunity for discovery, or at least at the initial stage, sufficient opportunity to introduce the types of evidence that you would need in order to prove intentional racial discrimination?
Well, I think, as Justice Newby pointed out, there is a right of the judge at the trial court level to say, okay, they've alleged that this decision that you've made is constitutionally suspect. I would like to see the evidence of the race breakdown of the properties you've condemned, or I would like to see more information about the decision-making process, because what 393K gives you the scope of review, and it says that the court shall ensure that the rights of petitioners have not been prejudiced. That gives them that directive to say, you court are making sure that this decision is not constitutionally suspect. Subsection A, in violation of constitutional provisions, including those protecting procedural due process rights.
And if their violation, if the violation of their state constitutional right is that the government is making a decision to enter into this process in the first place based on their race, how is it an adequate remedy that at the end of the process, sort of they've already suffered the harm, but at the end of the process, they can go to court and then present their evidence to say they should have never been subjected to this process in the first place because it was an invalid exercise of government authority based on their race?
Well, the appeal would come before the demolition is completed. The demolition would not be completed until all appeals have been exhausted, including the appeal to Superior Court, which would, again, allow a trial court judge, would allow plaintiff to enter the courthouse doors, present their claim to the trial court judge, have the trial court judge ask questions, potentially take testimony, potentially supplement the record, and make a decision as to whether the process was constitutionally suspect or not.
But this gets to the exchange your friend had with Justice Riggs. So if part of the claim here is that there's systemic racial discrimination and this is an effort to stop sort of the system-wide discrimination, then the condemnation of any particular home isn't the focus. It's stopping this government action, and that's what they want, is some sort of injunction that, that's a remedy for that, which seems broader than, there's no adequate remedy in a condemnation proceeding for that kind of claim. What's your response to that?
Well, to answer that question, that point that Justice Riggs brought up earlier, you can appeal any aspect. If the building inspector says you have to spend money to improve this home and repair this home, that is a decision that you can appeal. So every step of the way, you have the right to appeal up to the city council and then to Superior Court. So it's not the case that you have to wait until your property is ordered to be demolished. You can appeal along the way those decisions of the administrative agencies.
But what if the remedy that the plaintiffs are seeking is we want an injunction to stop the targeting of black people's homes in these condemnation cases, just generally. I mean, how would you get that kind of a remedy in a condemnation case?
I think there'd be a standing issue in part. You have to have a personal constitutional injury, and what this adequate remedy does, this process does, is prevent the injury to you, the constitutional injury to you as the appealing party. I don't know that you could come into court in the first place and say, I want to stop all racial discrimination in the town. You have to have an injury, and you have to address that injury in order to have standing. I don't know that you would have standing to come in and say, I'm challenging everyone's building who's been condemned over the course of the last 3 years. I don't know that you'd have standing to do that, because you would.
Isn't there an allegation this is like a pattern or practice of by the government? I mean, couldn't the argument be, yes, I mean, and I'm one of the people who's been targeted, so I can seek the injunction to stop this practice by the government, even though it will impact other people's rights as well?
And you have that right under 393. You have the right.
So you think in judicial review you could get that remedy?
I think you could make that argument in judicial review and say, I'm being targeted, and my proof of that is that there has been a pattern in practice, and here's my evidence of that. Or court, I'd like you to direct them to produce evidence of the race of everyone who's been condemned over the past 3 years, so that we can establish, because that was essentially their claim, is that this is, they don't argue that they are not subject to condemnation, that the building is in disrepair. I mean, these were bad wiring, roof caving in, those types of things. So they're not arguing that they're not subject to condemnation. What they were saying is that all of the condemnations, when you look at it, it's racially discriminatory. Now, that didn't bear itself out in discovery, but they had the right to make that claim, and they could have made that claim in a certiorari petition under 393. So the question really is there an avenue to address that concern? And there is. 393 specifically says, the legislature has said, if you've got a constitutional claim, if you think the decision made about your, that was applied to you was constitutionally suspect, 393K gives you the right to appeal that all the way up to Superior Court. And cases have held, and we've cited cases in our brief, that said, yes, the administrative body didn't have the right to address the constitutional claim, but that doesn't mean it will never be addressed, because there's an appeal. And the appeal, you can address the constitutional claim. So the legislature has very specifically said, this is the path that you should go down if you believe a decision applied to you by an administrative body is a constitutional violation. We've added this in here. We've added in 2009 in violation of constitutional provisions, meaning you have a remedy. You have an opportunity to enter the courthouse doors, address your claim. Trial court has authority to, delve into that and make the decision.
But if we say that in bringing a direct constitutional quorum claim, that you have to have tried to appeal every what you deem to be adverse decision by the city council, and presume with me that this is a systemic problem. So it's happening to, multiple people over multiple years in black communities. You're then essentially, absent the court inviting additional evidence, and you don't benefit from the rules of civil procedure norms. You have people, this could be spreading out over 40 years and, hundreds of different people. Like, how do you get to the big picture constitutional question if we say you have to do it via these piecemeal approaches?
Well, I think we have to do it these piecemeal approaches because that's what the legislature says is ultimately the answer. But, as a practical matter, if the city goes before an administrative, but goes forward on appeal, and the Superior Court says you're discriminating on the basis of race and sends it back down, if they do that once, that's probably going to be enough to stop the practice. If they do it twice or three times, that's certainly going to be enough. That is the remedy that the legislature has provided, which is and again, there's a standing issue if you're going to say we're attacking every single condemnation that ever occurred in the last, statute of limitations period. I don't think you have that right to, assert that claim in and of itself. because, you know, every one of these decisions is very fact-based. And that's really why it's supposed to go through this procedure, is because the decision to condemn or a property or require repairs is very fact-specific. It's what is the problem with the home, what needs to be done to repair it. You know, there's an opportunity for the owner to make repairs, go back before the council. It's a very fact-specific and intensive inquiry, and that's why I think the legislature set this path that, you know, if you're going to say after going through that process that you still believe your constitutional rights have been violated, appeal it to the Superior Court, and that claim can be addressed.
But isn't it the case that none of the facts you just laid out relate to the claim that's being brought here, which is that the decision of the city to focus on certain neighborhoods and certain property owners was a decision based on their race? So that it's not about, as you said, they're not saying their house was in good repair and that they're wrongfully saying it's not in good repair, or what they're saying is that the initial, the threshold question of which neighborhoods to concentrate this enforcement activity on, as again I said earlier, like a selective prosecution case, is improperly motivated by race.
I think I would frame it slightly differently, because I think what the plaintiffs are really saying is, I am being discriminated against. Your condemnation of my property was racially motivated, and my evidence for that is this history, alleged history of racially discriminatory, condemnations, which again, discovery didn't bear out. But what the plaintiff particularly is coming into court saying is not, City of Kinston, you've been discriminating against everyone. They're saying, City of Kinston, you discriminated against me, and my proof of that claim is this other, these other situations. So I think that's why this does address their specific claim, because their specific claim that they are making is, you cannot condemn my property because the way you're doing it is racially motivated.
Well, I think what they're saying is you, City of Kinston, can't have a policy that chooses which neighborhoods to focus on based on race.
And if they had a policy like that, then that could be brought up on appeal, and they could say, Judge, they cannot condemn my property because the way they went about this is improper, and this policy that they've got that says they're targeting race is constitutionally infirm, and you need to send it back down and have them go through the process again with a constitutionally sound procedure. That's, of course, not what happened here, but that can be addressed on this.
And presumably then your argument applies to every type of constitutional claim. So if instead the property owners were saying, you're targeting me because of my public speech, I came and criticized the city council and you've decided to condemn my property to chill my speech, that claim, there could be no opportunity for someone in those circumstances to halt the city's enforcement process. They'd have to go through that process. They'd have to then appeal to the Superior Court before they could have any hearing on whether or not the city was violating their First Amendment, or under the state constitution, their freedom of speech. Right?
I was going to say, under the state constitution, yes. As a quorum claim, yes, because you have an administrative remedy that you need to pursue. You could certainly bring a First Amendment 1983 claim, or you could do that for equal protection as well. Assert your rights under the federal constitution. But under the state constitution, under quorum, if there is an adequate state remedy, or if there is a procedure in place that the legislature has directed you down, you do have to pursue that in order to bring a quorum claim.
And so as I understand it, then we're departing from Presnell versus Pell, which I think predated quorum. But in that case, the court said that the school teacher had a slander claim, and she also had a claim that, maybe she was a cafeteria worker, but she had a claim that her termination was not proper. And the court said, you can go ahead and pursue your slander claim, but to overturn your termination, you have to go through the administrative process. Why shouldn't that same bifurcation, if you will, happen here. They can pursue through the administrative process whether or not their property meets the criteria for condemnation, but on whether or not they have a claim for violation of their right not to be treated differently based on their race, they have all of the benefits of being able to engage in litigation.
Because the slander claim and the employment claim are two different injuries. And I think here it's the same injury. It's the condemnation of the property.
But why-
Ultimately is what they're saying their injury is.
But why isn't their injury the fact that as a person of color, they're being treated differently?
That's the argument that they are making as to why the injury that they have incurred is constitutionally unsound. But the injury itself is the condemnation of the building.
Yeah, I'm just confused because as I said earlier, ultimately it may be that the city can condemn their property. The injury is that they should not be treated differently based on their race. And that's the harm to their dignity and the guarantee of our state constitution that they will not be treated differently.
Right, and I certainly understand that. I guess what I'm saying is that claim that I'm being treated differently based on my race needs to be brought through this procedure, because the ultimate injury that they're complaining about, again, is how are you being treated differently based on my race? My property was condemned, and it shouldn't have been because it was constitutionally unsound procedure that you employed. You targeted me. So the injury itself is what you look at under quorum as to whether there is an adequate state remedy. And in the context of like a defamation claim, the injury is an injury to reputation, where the claim for employment is loss of your job. And I think the analysis might be slightly different if you were saying, I lost my job and that's my injury. So I think it's, when you're looking at quorum, you're looking at whether there's an opportunity to enter the courthouse doors and address the injury that you allege is a constitutional injury. And you do have that here. I want to address a couple things. Again, the legislature, by adopting 393 and adding the constitutional analysis there, saying that you can bring a constitutional claim on appeal, that's not taking power away from the courts. That's just directing how the claim needs to get to the court in the first place. But the court still has the right to address the constitutional claim and the constitutional injury. And that's exactly the analysis that needs to be done under quorum is again, do you have the right to bring in that claim and have that injury addressed? And you do. The legislature gave it to you under 393.
So one of their arguments, as I understand it, is that this is not an adequate remedy. The administrative process isn't an adequate remedy because they're seeking monetary damages. Are those available under 393?
I don't believe monetary damages would necessarily be available, but case law has been very clear that just by adding a claim for monetary damages, that does not render a particular avenue that the legislature has created inadequate. In other words, you don't get the remedy you want. You get the remedy that the legislature has provided. And here, the remedy that they're really seeking is reversal of the decision to condemn their property.
But I thought they get the remedy that the Constitution requires, right? I mean, isn't that?
Right.
Okay. And isn't the remedy that they want here to not be treated differently based on their race?
Right. And if they had brought that appeal, they could send it back and say, okay, you need to do a different analysis here, and your decision to condemn their property was a constitutional violation. We're sending it back for a redo, come up with different criteria that are not race-based, and then go through the process. That's exactly what the legislature intends, is for that claim to be addressed in that way. Once again, I do have to point out, because it's being said here, and the city of Kinston did have a non-race-based policy. They looked at all kinds of factors that were not, they didn't even have the race of the people whose property was at issue. There's no record of who owned the property in a lot of these cases. So there was no race-based consideration. again, the cases that plaintiffs cited on this issue, where they said you don't, cases where he said you don't need to exhaust your administrative remedies are cases prior to 2019 when this constitutional language was added to 393. If, for example, you had a appeal statute that did not allow the court to consider constitutional issues, well, then that remedy is not adequate because the administrative body can't address the constitutional claim, and then on appeal, the trial court cannot address the constitutional claim. There's some cases along those lines where the statute governing the appeal didn't include a constitutional provision. And in those cases, the court probably rightfully said, that's not an adequate remedy because it doesn't address your constitutional claim. We can't hear that on appeal.
I want to go back, sorry, to the monetary relief question, because if we're in quorum territory, then as Justice Earls, points out, really it's for the courts to say what kind of relief is available. It's not really a legislative determination. So in analyzing whether this is an adequate state remedy, would part of that be an analysis of whether, under the state constitution, monetary relief should be available for this kind of claim?
Well, I think the North Carolina Constitution does not in and of itself provide a monetary damages aspect to it. That's a legislative decision, or in the absence of legislation under a quorum claim, you could potentially bring a claim for monetary damages. But this court, as well as the Court of Appeals, have been very clear. We've cited Abrams in our brief, Jackson v. North Carolina Department of Human Resources, that merely adding a claim for monetary relief does not render an otherwise adequate remedy inadequate.
Yeah, no, I do understand that you can't say a remedy is inadequate merely by alleging that you should receive monetary damages. What I'm getting at is, do we have to look at quorum and say, is this the kind of claim for which monetary damages ought to be available? So what's the proper remedy for this kind of alleged violation? Under
quorum itself and under this court's previous guidance, I don't think you necessarily need to look at the issue of whether monetary damages should or shouldn't be available. What you look at is, again, opportunity to enter the courthouse doors and present your claim, and two, some sort of remedy that addresses your alleged constitutional injury. Here, it would be reversal of the decision, because again, as you go through this process, no house is condemned and torn down before the appeals process is resolved. So, there is no necessarily monetary injury until that taking, or that, not taking, that's a loaded word, but until that demolition occurs, and that does not occur prior to the exhaustion of your appeal. So you would have the right to go into court and have the court send it back, and your property, your structure is unharmed during the interim.
Isn't a plus of the administrative process that the party gets to say to the local government, hey, what you're doing is going to violate my rights. Mm-hmm. You need to stop. And that gives the local government the opportunity to reflect on that and maybe not commit the violation or further the violation.
Absolutely. And I think that's a very valid point, that, the whole concept here is that there's steps along the process where these issues can be resolved. May be resolved at the administrative level. It may be resolved at the trial court level. But this is the system we have, that the legislature has put in place, that you have the right to assert these claims at the administrative level. They may not have the right to decide your constitutional rights, but they can hear your claim and act accordingly. And if they don't act the way you want and you still believe your rights are violated, then you have the right to go to Superior Court in front of a judge and say, they have violated my constitutional rights, and here's how they did it.
One quick procedural question. So you argued to the Court of Appeals that one ground for the entry of summary judgment that was proper was that there was no genuine issue of material fact, and the plaintiffs had failed to forecast evidence of race discrimination as a matter of law. You did argue that at the Court of Appeals, am I right about that?
Yes, Your Honor.
But it's not been argued to us because that wasn't something the Court of Appeals addressed in the opinion.
The Court of Appeals didn't reach that issue because they held
So it's
that
not
it
an
was-
issue really that we could take up, but it is an alternative ground to affirm.
It is, Your Honor.
Thank you, counsel.
Thank you, Your Honors.
Rebuttal?
Thank you, Your Honor. To address just a couple things here, one of the issues on whether or not it's an adequate state remedy certainly is whether or not there is whether or not we are requesting relief in the civil lawsuit that is not available through the administrative process. And I think it's clear from the process itself that we are. I mean, it's not just a prayer for relief. We're requesting certainly some type of injunctive relief to end this systemic discrimination, and we're requesting damages as a result of what has occurred because of this systemic discrimination. So I would think, I'm trying to read this case. I think it's Dominski versus State Board of Education, where the court said, finally, looking at whether an adequate state remedy exists, here plaintiff seeks monetary damages as well as injunctive relief through a permanent injunction preventing defendant from assigning or requiring plaintiff students to attend Lake Forest Elementary. The remedy sought here cannot be redressed through other means, as an adequate state law remedy does not apply to the facts alleged by plaintiff. In addition, when you think about the idea of what is the judge going to do, the petition for judicial review, what are his options? Like, if he determines there is discrimination, what are his options? Can he send it back to the city council and say, pay damages, or can he send it back to the city council and ask them to reconsider the constitutional issues when they really don't even have a right to address those constitutional issues? And the other thing too about it is there's no right to jury trial. I mean, we're talking about something so fundamental that it's in our Constitution. The right to jury trial is in our Constitution, and the right to be free from discrimination based on race is in our Constitution. And this so-called adequate state remedy to address these very serious, to the core of our Constitution, of racial discrimination claims, the way they're asking for you to approve does not allow for a jury trial, and that's certainly significant. And then
You agree that you have available to you a 1983 claim under the federal Constitution to raise similar issues?
Your Honor, yes, I would agree that there is a 1983 claim. I guess from my point of view, I mean, I was born and raised in North Carolina, lived here, went to law school here, and I'm African American. And when I see that Constitution saying it protects us from race discrimination, then I think that the state should honor that. And so I filed this in state court because I believe the state of North Carolina has a history of protecting African Americans in racial situations like this. I cited it in my brief and also in my petition for judicial review. And so I did not file in federal court because I think we can handle this here and based on our precedent. And I would hope that we handle it here for our citizens. I would, Your Honor.
Well, and you agree in quorum, you had both federal and state claims raised in the same case in state court, right?
In quorum?
Yes.
Yes, sir. If I remember correctly, yes, sir. Yes, sir. And then to address the harm, I mean, the harm is being targeted because of your race. I mean, that's what it says that's what the Constitution says is the discrimination. I mean, it specifically says, our Constitution specifically says that equal protection means you can't be discriminated against because of your race by the state. And so that's the harm. I mean, and that harm can't be addressed after the fact. What we were asking the court to do is find that there's systemic targeting that existed here, and to find that violated the Constitution. And if on summary judgment, if for instance there was systemic targeting of the community, shouldn't the plaintiffs be able to go to the court and file a direct constitutional claim? I mean, if you were satisfied, yes, they targeted this African American community, they knew they targeted. Wouldn't you expect that these plaintiffs should be able to come to this court for redress and not have to go through the city and go through this process? Shouldn't they be able to come here? And so we're on summary judgment, and I know, we lost the summary judgment. So I just don't know the court's basis for losing that summary judgment because he didn't say. I put probably more facts in the brief than needed for this appeal, but just my brief alone, if you look in the brief, I specifically talk about the fact the city has admitted to targeting this African-American community. They've admitted that they're doing that. We put in the evidence like Google Maps that show that the city is basically divided by Queen Street. On one side is the African-American community, the other side is not. And just about all the demolitions, they're clustered together. There's even testimony of them talking about, hey, let's cluster these demolitions in this community. And they admit to knowing it was an African-American community. After that, it seems like there's a jury, a community there that should decide what is our city doing, and is our city violating the rights of our African-American citizens?
So what's your response to your friends argued that one of the grounds, we have to just infer because it's not stated in the summary judgment order, but one of the grounds for summary judgment was your clients had not forecast enough evidence of actual race discrimination. What's your response to that?
My response is we have almost direct evidence of race discrimination. I mean, we've deposition admissions of the city manager that he was targeting the community. We've got the evidence of like I said, the Google Maps and stuff showing that the community was targeted. We've got minutes from the city council that shows that they were targeting the African-American community. It seems like to me the evidence is certainly strong enough to survive summary judgment.
But you didn't brief that to us because the Court of Appeals didn't address that, so.
I didn't brief it to you. Also, I asked for review, a couple of different bases for review. You only allow review on the substantial constitutional law question of whether or not the Court of Appeals erred in stating that we had to exhaust administrative remedies. So that's the only issue here. That's the only reason we haven't addressed it. And I would say, there's a bigger picture, I think, when we back up for a second, look at the bigger picture. The bigger picture is that this court, the court system in this court is the one that decides constitutional law issues. It's not, the legislature does not have a right to start, siphoning off, your right to decide these constitutional law issues to other bodies or anything like that. It doesn't. It doesn't have a right to start trying to pinhole how we can get to this court, right? This court has a right to decide the constitutional law issues, and I would ask you to just, there's so many different ways that this thing can be spun if you don't, demand that we have a right to hear these. There's so many different little things that could happen in the future that I'm hoping that this court says, look, we have a right, this court system, and we ultimately have the right to decide constitutional law issues like they did in Marbury versus Madison and everything since then. And then we have a system in place that can handle it, and it's got to come through us, and these people have a right to make direct constitutional claims to us. And I hope that, I hope that anything you do doesn't diminish in any way, quorum, and the right to recover, not just relief through the direct constitutional claim as far as filing the claim, but also the damages that are recoverable. And if there's any questions for me? All right, thank you.
Thank you, counsel. Mr. Clerk.